Welcome to a special post-oral argument edition of Court Accountability Action meets Legal AF meets Strict Scrutiny. We've got Leah Litman here, Professor Litman here back. We just did a great interview with her yesterday. I love these crossovers, Leah, where Strict Scrutiny and Legal AF and Court Accountability all kind of get together, talking to our overlapping audiences about really important things. It's hard to believe with 13 or so emergency applications, but this was the first and last probably for the term, unless they take something up on an emergency for oral argument of this term about a Trump policy. And even though we framed it and a lot of the news media ran with it as the birthright citizenship, will the beating heart of birthright citizenship be ripped out of the Constitution, or will the Supreme Court stop it? I don't know if that's what that was all about. What the issue that was up on that appeal and that oral argument was about something else, about whether federal judges are going to have in their tool bag the ability to use nationwide injunctions, just the way they've done for the last 70 or 100 years, just the way they did during the Biden and Clinton and Obama administrations, to be able to make a ruling to block a policy that's unconstitutional or statutory violation until it makes its way, or as the phrase of the day yesterday, till it percolates its way from appellate court up to the we're going to fall over here, until we get to the United States Supreme Court for them to make an ultimate ruling, which is the law of the land as interpreted by the Supreme Court. What I wanted to know from you, two constitutional scholars who are deeply invested in this, what did we just watch during this 2.5 hour oral argument led by John Sauer? He's getting increasingly difficult to listen to for many reasons. John Sauer for the government as the Solicitor General, Donald Trump's former criminal appellate lawyer. And then a couple of advocates, one from the New Jersey Solicitor General, who, by the way, 10 years out of law school.
Terrific.
I think he is an amazing advocate. I looked him up, like 2014 from Harvard. Holy cow. And then Ms. Corcoran, who runs the institutes under Georgetown related to these kind of things as well. Let's start with Leah, who, by the way, not to leave out anything that's not important, who has a timely new book that we have our editions of here called Lawless. We'll put it up on the screen too. You gotta buy. People ask me, Popok, we want to read to get ready for your Legal AF law school classes. What's on the summer reading list? Lawless. And it will help you decipher what you just watched at the oral argument. But I want Leah and Alex to talk about it right now. Leah?
Yeah, so it will definitely give you a sense for how the court enables the Republican Party's lawlessness as well as their lawless racial grievances against the 14th Amendment. But first, thank you so much for having me again. I also love these crossovers because part of what gives me hope when everything feels really bleak is there are more smart people now focusing on the courts and trying to talk to people about the courts, which I truly believe is an important step for how we get out of this fustercluck. But on the oral argument itself, so much was wild about those 2.5 hours. I was listening to it on a plane to DCA, and I didn't know if I was shouting because I was scared about landing in DCA, or if it was because of some of the things the justices and John Sauer were saying. So one of the things that struck me is, even though I assume the court took this case because they don't like nationwide injunctions, they picked the worst case for deciding against nationwide injunctions, and it doesn't seem like they are going to absolutely prohibit them. And so that leaves me with the sense that, did they just take the case to give the Trump administration a partial win and allow them to implement the policy for some time by telling the lower courts, you got to do a do-over and don't issue nationwide injunctions in other cases? That was one really weird aspect of the argument for me. And then the other was, I'm sure we'll come back to this, but the Republican appointees were really showing up and showing out.
Yeah. Alex, why don't you take it from there?
Yeah, Leah, I want to get into that a little bit more, because I think what we're seeing in this case is an attempt at resolution of some escalating clashes between executive power and judicial power in response to mostly lower court orders standing up to overreach by the Trump administration. We've seen attacks on judges, attempts to try to get them impeached. claims that this is a judicial coup. It feels to me that they're using this case as almost a feeling out grounds for resolution and maybe a tamping down of some of the temperature on that. Perhaps, and this is maybe where you're getting to the partial win for Trump here, by disempowering these lower court judges from their ability to impose nationwide relief while retaining for themselves the ability to work with the Trump administration to kind of get there in a way that everybody can live with from their kind of collective perspective. How do you see that playing out? And what would that look like in a case like this if indeed the Supreme Court majority narrows the ability of these lower court judges to impose nationwide injunctions? How would that play out? We saw some real concerns being expressed by some of the justices like Kagan and Jackson about what they described as a potential catch me if you can regime here.
Yeah, so I think they are going to do a few things. One is they're going to narrow the set of cases where lower courts can issue nationwide injunctions and basically arrogate to themselves and themselves alone the power to resolve these questions on a nationwide basis and block a policy on a nationwide basis. I think they will also probably insert, here's an additional procedural hurdle you lower courts have to clear, or an additional set of factors you have to consider before doing anything approximating a nationwide injunction. And I think what that's going to do in the interim in this case is just chaos and cruelty, because the administration took this position that when a lower court, so let's imagine a trial court in Texas, says this executive order is illegal and this child is a citizen, the administration is taking the position that they have to do fuck shit based on that ruling as to any other individual. So every other baby.
That's a term of art, by the way, for our audience. Yeah. That's a legal term of art. You are now qualified to use it after
it's
watching.
There in the constitutional debates. You can see Hamilton in that.
And fuckery is the corollary.
Yeah, well, I'll just move on. But anyways, so, John Sauer was taking the position that, a lower court, a district court, a court of appeals, they might say something, but we administration are not obligated to follow the reasoning of that decision outside of the specific plaintiff or plaintiffs who brought the case. And a troubling part of that to me is the Supreme Court justices just seemed fine with that, maybe. Like only Justice Barrett of the Republican appointees was troubled by this suggestion. And Alex, I think that's exactly your point, which is the lower courts are standing up to Donald Trump. They're taking a lot of heat for doing so. And it seemed to me like the Republican justices were fine throwing them under the bus and basically saying, the administration doesn't have to listen to what you guys say, just us.
Yeah, I just to jump in there, the different, you did it well in the Substack piece that we published on Legal AF. I thought there were a lot of different things going on up on that bench that had not always a little to do with the argument, but they were out in the open, right? You've got the group, which also matches well with the alt-right of the court, that is in favor of the unitary president, that worked in the executive branch. You got Kavanaugh who says out loud, well, he wants to get a lot accomplished, so all these executive orders are really great. They're really great unless they color outside the lines and violate the Constitution or his obligation to administer the law, to be the executive of the law set by Congress as opposed to make new law with executive orders. So you had that battle going on, right? You had the other battle going on, which is that other subset, which is that same group led by Gorsuch that doesn't believe in universal cosmic injunctions at all. And that's where you had Clarence Thomas lead off the whole thing. I like the old version of Clarence Thomas when he didn't talk for 15 years. Now he leads off oral arguments. Let's talk about a bill of pleas. I'm like, oh, here we go. All right. So look, for those that are watching at home, the Defend the Democracy home game, there is already a vehicle through Rule 23 of the Rules of Civil Procedure to allow for class action. I get a lot of comments, I'm sure you do too in your podcast, about, Popok, I want to bring a class action against Elon Musk and the government. Yes, and there is a mechanism for collective or class action where people can get together who have similar harms, who can join together and then certify a class and then seek redress. Yes, absolutely. But this government has opposed every effort to use class action in lieu of a nationwide injunction. See Boasberg. I was surprised the advocates didn't bring up Boasberg, because when Boasberg in the JGG case about the 250 Venezuelans who were sent to El Salvador in the middle of the night over his ruling. He said, you know what? I'm going to do it. I'm not going to do a nationwide injunction. I'm going to do a class action certification of this group impacted by the proclamation of Donald Trump. And I'm going to add an order to it, an injunction to it. That's what I'm going to do. Oh, no, you can't certify the class. You see, that's the rub. They never want you to be able to bring this up to the United States Supreme Court. I mean, one of the it came up from, you'll tell me which justice, I can't remember. One of them said, maybe it was Kagan. Why would you, or Sotomayor, why would you ever, right? Why would you ever bring this case to the United States Supreme Court? Wouldn't you just leave it where it is? What would be your incentive to ever bring it to us? So we had a lot of that going on where they're talking to each other. A lot of my audience, because we had about 80,000 people that watched it with us, they were saying, oh, she's mad at the advocate. Or they're not. They're talking to each other. They're trying to get the advocate to make their point for them. And when they throw them a softball and they miss, even if it's on their side of the argument, they get a little frustrated. No, that's not my point. Here's my point. And let me make it for you since I'm not getting it out of you. So talk about the why class actions don't work, which is where a lot of them were going as an out. And then we'll talk about what we think is going to happen to the nationwide injunction after this ruling.
Do you want to talk about that, Alex, or do you want me to?
Oh yeah, you should do it. You should. You're the real. You're just playing some on you.
So Justice Kagan, I think this is the moment where she basically pants to the Solicitor General, because the Solicitor General is saying, well, okay, solution here. They just need to bring this as a class action, and therefore they can get the kind of relief they want. And the real problem is courts are effectively ordering class-wide relief without making the determination that a case can and should proceed as a class action. And Justice Kagan asks him, well, okay, are you saying you would be okay with class-wide litigation here? And he says, well, no, I would oppose that. And he tried to draw these insane distinctions between different groups of children in the proposed class. He would say, well, we would want to treat separately the children of unauthorized migrants from the children of people who are lawfully but temporarily here. First, have you heard of subclasses? Second, not a relevant distinction. Third, just get out of here. So they would oppose class actions, which would mean it would be happening on an individual by individual basis. And
every baby needs to bring a lawsuit.
The government's position is every baby needs a lawyer now, which, okay, that's something. But I think we should make clear how that chaos might play out, given what the Trump administration is doing. They are deporting babies. They are deporting U.S. citizen babies. So if the Supreme Court sends this case back down to the lower courts and there isn't a nationwide order in effect blocking it, I am very concerned that they will move aggressively and quickly and without sufficient process to try to deport some, it's not deportations because they're U.S. citizens, but expel some baby U.S. citizens to other countries. And their position is also that no court can then get them back.
Right. Because they have. Where are those 3 kids out of Texas?
And it's completely unclear what the recourse would be, right? It seems quite clearly to me from that argument that Sauer, the Justice Department, they're content to lose these cases on an individualized basis. They know they'll be able to stop class actions. You know, if people are able to, you know, if mostly poor people are able to muster the resources to individually sue, some of them might be able to obtain class-wide relief, but that's probably going to be exceptional. And then even beyond that, they were reluctant. Sauer was really reluctant to commit to respecting circuit precedent. Even the rulings of federal circuit courts, he was reluctant to.
And that was in response to Amy Coney Barrett. I mean, when you've lost Barrett on an issue, like, well, why do you care if it's class action or it's federal, if it's universal injunction? It gets here apparently the same. Why do you care? Look, I'll say one thing about John Sauer. He was not at his best yesterday.
What does his best even look like?
Well, I've said the longer he's advocating a couple of cases before the United States Supreme Court where they're already ready to rule for you, that's one thing. But being the Solicitor General, where you have to show up and argue 30 or 40 of these or whatever it's going to be, I knew he was going to wear thin on this, even on the Republicans, because look, I've done oral advocacy before not Supreme Court, but other appellate courts. And you're making your notes for rebuttal, right? And you're trying to figure out in an hour and a half where you've been hurt, 2 or 3 places, and your very short rebuttal. He stood up and started talking about slavery again. He thought he was hurt on slavery.
Maybe a sign your argument isn't going so well if you're losing on the issue of slavery.
Right. Like, that's your lead for your rebuttal. So let's turn it to Amy Coney Barrett, because you and I, Leah, talked about it in the pregame show, so to speak, in the interview, about how to filter your Lawless book and your paradigm here, the filter here, about Amy Coney Barrett. So what did you make of how, and she spoke a lot, her position taking, or at least the questions she was asking, and her getting very impatient with John Sauer. Like that didn't answer the question for Sotomayor. Let's get back to it. What did you make of that? Is that just performative? Is that just kabuki theater? Or can we read something from her performance?
I think some of her performances during oral argument are, performative both sidesism. I think she did that in some of the cases about Texas SB 8, the bounty hunter law that shut down abortion access in that state. Here, however, I read her to be sounding real concern about some of the administration's positions, in particular, as we were just talking about, their position that they wouldn't actually treat circuit precedent or district precedent as governing other cases and other parties who weren't plaintiffs in the case. Because again, that world is just chaos when you're talking about all of these children, particularly if there isn't a certified class action. At one point, I think after the SG repeated, I'm saying maybe we wouldn't follow circuit precedent, she just said, really? Really? Like
he said, did I miss this, or did I misinterpret or mishear this? At one point he said to her, she said, well, if the Second Circuit, and you're in the Second Circuit, which covers New York and other states, if you're in the Second Circuit and the Second Circuit rules in the Second Circuit, you're not going to abide by Second Circuit precedent. Didn't he say there could be a possibility he would not abide by it?
Oh yeah, he reserved the option to not apply Second Circuit precedent in the Second Circuit as to other individuals there. Like doctrine, precedent, what's that? Don't know her. And Justice Barrett, I think, was also concerned about this idea that's related, which is whether lower court rulings can offer relief or benefits to non-parties, individuals not in the litigation. And there, I think she was echoing a point that Justice Ketanji Brown Jackson had made, which is it's insane to think that lower court rulings cannot incidentally benefit parties who aren't before the court. Because as Justice Jackson said, look, if you tell the government to stop illegally, guess who that benefits? Literally everyone in the country. And no one's ever thought that it's improper for a court to award what's called facial relief, where you basically prevent them from applying the statute to any case or anyone. And yet the federal government seemed to want to ask the Supreme Court to cut back on that too. So I read her concerns, honestly, as pretty genuine. I don't know where the fifth vote comes from to full on deny Donald Trump's stay application.
Leah, I have a question for you. I'm just trying to work this out, because this is all against the backdrop of this constitutional clash that we've seen. We've seen statements from J.D. Vance indicating that if the Supreme Court stands in the way of what Trump is trying to do, they will defy the Supreme Court's orders. We've seen that mindset from Russell Vought, who has quietly now taken over DOJ, who possesses this post-constitutional vision for the American future that very much entails monarchical power in the hands of somebody like Trump. On the one hand, Sauer seemed very clearly to be trying to mitigate concerns from the court that this administration was going to just outright defy the Supreme Court. But as we just discussed, they were indicating that they wouldn't necessarily respect circuit-wide precedent from, say, the Second Circuit. What distinction is there? I mean, the argument about the lower courts is that there's no Article III jurisdiction to impose that type of relief beyond the scope of just the parties in the case. But what's the difference between the Supreme Court and the lower courts when it concerns a question like Article III jurisdiction to provide that type of relief?
There isn't one, but the Supreme Court is 6-3 supermajority Republican with 3 Trump appointees. So obviously that court is better and bigger. But apparently that's not even satisfying to Donald Trump. Like, he didn't think the oral argument yesterday went well enough because he posted on Truth Social earlier this morning, and that's what I was just pulling up. The Supreme Court is being played by the radical left losers who have no support. The public hates them, and their only hope is the intimidation of the court itself. So,
did anybody find the New Jersey Attorney General, Solicitor General, to be intimidating in his argument?
He was so nice and willing to answer the justices' questions.
Yes, but no, stay in the buckets. Stay in the buckets. No, I don't. I know you want to go to 1, but let's stay in 3. My audience was like, "Can we kick the bucket? Can we enough with the buckets?"
Seriously. No, but Alex, I think that's exactly right. Like, there isn't a difference. If we're talking about what does federal law authorize the justices to do, what do the civil rules authorize the justices to do, they authorize the same things as they do for the lower courts. So there isn't a real distinction. And again, I just worry that the justices are going to be okay giving the Trump administration permission to be lawless and ignore lower court rulings when they're against them. And they're fine because that will preserve their own authority. And it mirrors, in some respects, a really troubling line, a moving goalpost that some Democratic politicians have been pushing, which is the real constitutional crisis is when the administration defies the Supreme Court, but not the lower courts. And that is just wrong.
Yeah. So let's talk about counting to 5. Let's we're playing snooker here. Let's slide for now Amy Coney Barrett over with Ketanji Brown Jackson, Kagan, and Sotomayor. Now I got 4. Yep. And for those, the shorthand for our audience is whoever counts to 5 gets 5 votes. That's the opinion, right? That's the law of the land. So let's focus on Roberts. His sole comment was, "Can I hear the answer?" Other than that, he said very little substantively. But he's got a court that is under the existential threat to the court is the existential threat to our constitutional republic, and he knows it. So what does he do here? Does he try to, as he always does, try to give everybody a win? So yes, you can use injunctions nationwide, but under these very limited circumstances. And on the birthright citizenship, it's a no to the Trump administration. He knows what happened when he gave immunity to Donald Trump. Is he now going to give him the ability to thumb his nose at lower federal courts?
I don't think he is going to give a straight up no to Donald Trump. He was, as you were saying, cutting off Justice Sonia Sotomayor. And the rest of his time, I heard basically saying, well, if we say no nationwide injunctions in the lower courts, or we send this one back down, no big deal. We'll be able to fix it in some time. He noted, we can act quickly. Look what we did in the TikTok case in 30 days. And so he just seemed to be playing down and minimizing.
The citizenless babies at the airport seem to be fine with him.
Right. He just seemed to be playing down the implications of not giving a direct no to the Trump administration.
Mm-hmm. That's true. I agree with you. We could do things pretty quickly when we want to, but the problem is you never want to, except when it's like, that last 1 o'clock in the morning decision to ground the planes back to Venezuela, to El Salvador. So if we can't count on Roberts,
exactly.
Alito's done, cooked.
Yeah.
Kavanaugh cooked. Gorsuch cooked and baked
that
in
leaves
this area.
Thomas.
Oh yeah. Okay. Cooked. So yeah, it's going to come down to Roberts. It's going to be another Roberts written opinion. Maybe.
I know. And I think he will do the split the baby thing where he says, maybe it would be possible sometimes, but lower courts gotta, try again.
Yeah. And go back and do a quick class certification. And then the other thing about the advocates, they didn't really talk much about what's happened in the real world in the courts as much as I thought they would. I thought that was a missed opportunity to say, look, we just tried the class action route. They didn't like that. They didn't like the nationwide injunction route. The reality is they don't want a quick or any review by the United States Supreme Court while they do everything below and this administration's time is up.
Exactly.
Right? That's what we're watching.
And, I think if the court can keep it in these abstract, non-tangible, non-real world harm contexts, it's going to be happy to let this stuff proceed. We've seen it in other contexts, right? This is how Republican gerrymandering in the states was greenlit, right? They said, oh, just in this instance, we happen to not have supreme authority to decide every question of law and policy. This is a political question that we can't decide. I think we're seeing a similar dynamic here where they're trying to keep their fingerprints off what they know is a deeply toxic, damaging agenda that they are effectively going to allow to proceed. It sadly seems to be.
Alex Aronson, Court Accountability Action, Professor Leah Litman, Strict Scrutiny, and a brand new book. We'll put it up on the screen. Lawless. This is your summer reading. How the Supreme Court runs on conservative grievance, fringe theories, and bad vibes. Only great vibes here, Leah. Whenever you join us on Legal AF, we have an open door policy for you. Anytime you want to join us, I'm happy to have you. It would be really fun for our audience as well. Thank you for being here.
Well, thank you. That's very kind.
Until our next Leah Hot Take, Michael Popok signing off. I'm Michael Popok, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touch's Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popok Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popok Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popok Firm today at 1-877-POPOK-AF or by visiting my website at www.thepopokfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popok Firm, fighting for your justice every step of the way.